Good morning. Today we're going to talk about the Puerto Rico Public Corporations Debt Enforcement Act, an act that was passed in June 28, 2014, that's been nicknamed, Spanish acronym, La Quiebra Criolla. Less than 24 hours after La Quiebra Criolla was enacted into law by the governor of Puerto Rico, two funds, Oppenheimer and Franklin, mutual funds, with about over $2 billion in debt or bonds, filed a suit, a litigation in federal court, District of Puerto Rico. And later on, Blue Mountain Capital joined the suit. They're different, although they're different litigations, they both were consolidated by Judge Francisco Besosa from the District Court of Puerto Rico, Federal District Court. They both seek a declaratory judgment to declare unconstitutional the law, the act, the Recovery Act, as it's been called also, and to void the act under constitutional provisions. As we've said before, this act is modeled or mirrors Chapter 9 and 11, supposed to be modeled after that, but lacks the creditor protections under 1129B of Chapter 11. So they're not identical, and we will explain them a little bit more before we get into the litigation. The act themselves were passed as part of a response by the government of Puerto Rico to the fiscal crisis, the fiscal emergency of Puerto Rico. We've had about over 6 years of negative growth on the island, unemployment over 15%, budget defaults, and basically a series of governments for the last 10 years that are using floating debt to pay current operations, which has been criticized. The agencies targeted by the Recovery Act are basically four. Doesn't cover all of the government of Puerto Rico, but these public agencies, the power of the water, the transportation, and ports, PREPA, PRASA, ports, and highways, basically. These four agencies owe over $20 billion out of the Commonwealth of Puerto Rico total government debt of about $71 billion as of 2014. The deficit of at least three of these companies, PREPA, PRASA, and Highways, is in excess of $800 million in 2013. PREPA alone had a debt of $9.6 billion and also short-term bank debt. It owed to three different banks of about $500 million when this law was passed back in June 28, 2014. The government of Puerto Rico passed this act, the Recovery Act, alleging that there was a gap, that Puerto Rico had been excluded from Chapter 9, which deals with municipal entities, filing of bankruptcy in municipal entities under 11 U.S.C., the bankruptcy law of the U.S., and that Puerto Rico was not considered a state for purposes of the definition of who can be a debtor under Chapter 9. So based on the fact that there was no legislation in Puerto Rico and there was no legislation under the Federal Bankruptcy Court or in the U.S., the government of Puerto Rico thought it was proper to legislate and cover this field, which had not been covered, they said, and now we know differently, by U.S. Congress. Also, most experts think that Chapter 11 cannot apply to agencies like PREPA, like PRASA. These are public utilities, monopolies of the government of Puerto Rico. Other people think that they are eligible for Chapter 11, the traditional Chapter 11, as any business, because they have board of directors, separate board of directors. They're appointed separately. They have independence of judgment, and they issue their own bonds. There's some litigation in circuit courts and in the District of Puerto Rico that have held under the immunity clauses, also that they're considered more like private agencies, and maybe a possibility would be to file a Chapter 11 for one of these agencies like PREPA. The government of Puerto Rico also argued in the in their defense of the litigation brought by Oppenheimer and Franklin, that there was nothing in the Puerto Rico legal system that allows restructuring of debt. And there being nothing in the U.S. system or no law in the Puerto Rico system, there was a gap that they were allowed to fill because Congress had not legislated regarding restructuring of the territorial debts of Puerto Rico. By the way, what this brought about when this law was passed, because it was passed without public hearings, it was passed overnight, and it was effective immediately. There was a lack of transparency, lack of consultation with any of the bondholders on Wall Street. So it brought a lot of bad publicity to Puerto Rico, and the rating agencies stepped in right away, Standard & Poor's and the rest, and devalued PREPA to junk status, and also brought down all the other Puerto Rico obligations, including the COFINAS, which are earmarked bonds from sales taxes, and GDB, which have special protection, and even the GOs, which have constitutional good faith and credit from the government of Puerto Rico, and are not covered by the new act, by the Recovery Act, by the way. They even devalued these other bonds of the government of Puerto Rico, to the big surprise of the government of Puerto Rico. So they were taken by surprise by the reaction of Wall Street and the rating agencies. As we were saying, after the law was passed, the Recovery Act was passed, which, by the way, is Act number 71 of 2014, the banks and the bondholders got together. And of course, after the devaluation by the rating agencies of all the obligations of the government of Puerto Rico and its agencies, the banks and bondholders got together and decided to negotiate with PREPA. They came to an agreement for a moratorium, and which is still going in effect. In March of 2015. There should be a report in. There's been an appointment of an overseer. So, and there's been a forbearance agreement signed with banks and bondholders. So the agency is in the process of restructuring. But going back to the act itself, it's important to mention who is eligible and what kind of an act is it? Is it a bankruptcy act or is it a composition? How can we name this beast of the Recovery Act, Quiebra Criolla in Puerto Rico? First of all, the exclusions in this act are very numerous. It excludes GDBs, Government Development Bank. It excludes the government obligations, general government obligations. It excludes the COFINAS, University of Puerto Rico, and all the municipalities. There are 74 municipalities that most of them issue bonds in Puerto Rico. And basically this act was addressed to 4 agencies, which I mentioned before: the power, the water, the transportation, highways, and ports. How does it work? Well, the act has the first section of the act, the first part of the act, deals with general matters, just like Chapter 3 and 5 of the U.S. Bankruptcy Court. But the Chapter 2 is a consensual debt modification part, and Chapter 3 is a court-supervised restructuring process, which is more like a Chapter 11 under the Bankruptcy Code. How does the consensual part operate? This is a court-supervised process. It could modify, it's used to modify interest rates, maturity, and extend terms of loans. It requires a recovery program be adopted under the court authority, and it can affect debt. It has an automatic stay, just like Section 366 of the Bankruptcy Code, although it's really suspension period, it's called, not automatic stay. And it's for 270 days, which may be extended. There's no actual filing under Chapter 2 of the new law. It's triggered by basically posting on the webpage the intent to affect one or more creditors or a group of creditors by the specific agency. And there is an obligation on the part of the agency to negotiate with affected creditors and to submit a recovery plan in good faith. There are voting requirements to accept and basically cram down the dissenting creditors. As 50% of debt entitled to vote must participate, and 75% of those must be in favor. So there are some safeguards for dissenting creditors like you have in a normal Chapter 11 reorganization case. There's court confirmation or court approval of the plan, and once a plan is approved, it binds all creditors. Now, Chapter 3 is not a voluntary program like we just described in Chapter 2. Chapter 3 doesn't call for consensual approval, but rather it's a judicial restructuring. Court-supervised judicial restructuring is the way the Act reads. And instead of a plan to be confirmed, it's an enforcement plan. And there is an actual filing of a petition like a Chapter 11, contrary to Chapter 2, which I said you just have to post on the web page that you intend to use the chapter. There is an automatic stay on all affected creditors that are listed, so all actions against the agency are stopped by the mere filing of the petition, just like in bankruptcy, U.S. Bankruptcy Code. There is a debtor in possession concept. In other words, the agency continues operating from day to day once the case is filed. And there is a liquidation value test similar to the best interest test in Chapter 11, but a little different in language, more lax. Only one class is required to vote to accept, and that binds creditors. And you have also the voting requirements of majority in class and 2/3 of affected creditors to bind minority creditors to the plan that's being approved, not confirmed again. So there is a cram down, permits a cram down of not consenting creditors as in a Chapter 11, but without all the 1129B protections that you would find in a normal Chapter 11 case in a private company. This has, of course, been one of the arguments against the law, that it goes too far and modifies obligations without protecting creditors. And I think it was behind a decision that we'll talk about a little later today, issued by Judge Francisco Besosa of the U.S. District Court of Puerto Rico, actually voiding this act on constitutional grounds. So the suit by Franking and Oppenheimer and Blue Mountain Capital that followed is a declaratory judgment, a request for a declaratory judgment, and a request to hold by the court to hold that the act violates the U.S. Constitution, the bankruptcy clause, uniformity of bankruptcy clause in Article 1, Paragraph 8. It also, they claim, violates the takings clause, and it violates the impairment of contracts, prohibition of impairment of contracts in Article 110 of the U.S. Constitution. One of the issues that was really controversial in this case, and was the defense of the Puerto Rico government, defended this litigation against the three funds, is that the matter was not ripe for adjudication. Under Article 3, there was no case in controversy under Article 3 of the Constitution, is what the government of Puerto Rico argued. Some of the special revenue bond holders also alleged that there's discrimination because they were not excluded specifically from the coverage of the act, like the general obligations and GDB, the Government Development Bank bonds, and that they're being singled out for impairment, contrary to others that were specifically included. This argument was not brought out in the court, but it's something that's been argued by this group of bondholders.